Council, if you're ready to continue, you may please proceed.
Good afternoon, Mr. Chairman. We are ready to proceed. Mr. Usher, kindly get the witness. Thank you.
Yeah, there you go.
Good afternoon, Mrs. Bensouda.
Mrs. Bensouda.
Good afternoon, Council.
Council.
I hope you had a good break.
Yes, thank you.
Inumbara.
Unfortunately, because of the Ramadan, we are not able to offer you TRRC hospitality.
Thank you for offering it in any event.
Mrs. Bensouda, just before the break,
Mrs. Bensouda,
the chairman preempted me by going into decree number 1.
Sorry about that, Council.
That's all right.
That's what chairmen do.
Indeed. And this was the first decree that was passed under your tenure as Attorney General, Acting Attorney General. And I believe there were 5 more that were passed under that capacity. Perhaps we can, before we go into the decrees, just give us a background into what was happening in the country then at that point. After you had met the chairman, and he had indicated his desire to rule by decree. And gave you instructions for the drafting of decrees. In terms of the human rights situation in the Gambia, then what was the situation?
As far as I could ascertain, and they really depended a lot on rumors.
Ntesikulu itandilo nyaming wotembo kujamabe dendi munela menketa ngunu kumoliti moila moy kumolu menukafo.
As I said, all ministers had been detained. I believe all senior military officers above the rank of lieutenant were also detained, barring the only person I know who was above the rank of lieutenant, I believe, was Lamin Kababajo that I met, who was not detained.
Andu tembo sojar bunda la menul fanal la makamo be lieutenant ye santo wolo jamabe kono ye mutaleke sindidula keleng fase ke mo kelinti de Lamin Kababajo ni me nyoje men mantara mutamolu kono utumo.
All senior police officers were also detained.
Police kunyaton ko lu fanalu be ye be fanan sindidula keleng.
There was a great deal of tension in the atmosphere.
Utumo sobinyolo sembo be warari mbake fonyo kono.
Most of the vehicles you would see on the road were military vehicles driving at top speed to and fro.
Watembo ekamoto jamaje siloka be kake sojar moto leti inimbori balu bitakan ay tanin na e bitala bina.
And as far as you were concerned, the detentions of the minister, as well as the others you've mentioned, were they lawful or not?
Minister, minister, ni kemu da ke sindi dula kiling, ani mansa kunda do kula nyato ka kota wal kemu da ke sindi dula kiling, ani tanko bunda kota mo kemu da ke sindi dula kiling. Italo londo fo oni luata talema.
Of course, they were not. Nothing that the military could do would be lawful. Did or could do would be lawful.
Amanke luate. Katu tembo sojarol ye ko kundinke otakeno la loi la siloti ye membe tamande ani loi manta.
A military government is not lawful.
Sojar man sakunda fawni loi le manta.
And at that point, I agree that it wasn't lawful. Do you remember, or do you know any other human rights violations that occurred during that time, apart from unlawful detentions? Because we have received a lot of testimony about how some of the ministers were also tortured during this time.
Ninga bota ni mola ni minister ni tanko bunda nyaaro nga kota mo ke mu ke sindi dula ke mo kayla o nyantu tinya fo yalla na fo hada ma nyanti tinya dol ketal ban katu nga sedan dul jamal der soto janko minister dol beje mi alon ko ye dol ye muda gabri ye sindi dula ke ye dol beje ye tajire yale ngo sedan dol soto jan fo ye dol lon na ba men alon ko ila ta ni mol kamba.
At the time we could not know that.
O tembo de tawolo nola.
What we would hear rumors of people being whipped. Basically, people being detained in Mile 2, not only in police stations and so on, but in prisons.
Andu ye molu mutamene ya lonko ye samba banko kaso bunda abala kate soronje hana manke police station olu damantide bari ye samba kate soron Mile 2 kasola.
For a lawyer, that is horrendous because, as we all know, the only institution that can put anybody in a prison is the court.
Odun lawyer la karola wo mukijate ku baleti katu ndel langa ngamello ndalta melna wala mnyinti ko kiti bunda leo sembo soto kamo kiti ndini lua ya muta ya soron.
But later, through decree number 3, Mrs. Bensouda, the council was given that power to detain people.
Bare sedo nyato do mande decree sabanja woni nginata na sembo di council do kula lale nyato ko lale puru isi momo murande no ya samba kaso ka sindi dula kilin.
And they assumed this sort of semi-judicial function as well as other legislative functions.
Andong degree ni narana sembo di la kolem comme loi bundaro kiti bundale sembo membe bulo no sembela kilingo ni narana kurundu kanao ke ka fute tol council nyaton kolma kamo samba kasoro ke sindije.
Decree number, no decree gave the military any power.
Decree ti jeme ye sembo di sojarol.
The soldiers were already detaining people in Mile 2.
Sojarol ya muta drone kamolu muta kate soron Mile 2.
Decree number 3 did not give the soldiers power to detain anyone.
Decree sabanja man sembe wo sembe di sojarol la pour kamolu muta ke soron.
What decree number 3 did was try to put in place a framework within which if you were detained you would be dealt with.
Decree sabanja e sarto men nati men wala nyindi ko ni teliye muta hanfo ye sindi dula killing bitung itel lamira roto men nyanta kelela isiokela.
Received evidence that apart from the fact that this decree gave them the authority to detain, but when they actually went to court, when they were arraigned in court for offenses, that the magistrates' hands were tied, for example. They had no discretion to grant bail because of that particular decree, because it did give the council that power to detain, and that power was no longer in the courts. They could no longer remand prisoners.
Nga sedandro men so dañi decree sa manyo wala ñindi ko ñi decree sa manyo ay sembo di ñi council members wala council mo lale kadum hanni ngatra mo mu ya samba kitiyola ya samba kasoro magistrate même kiti la ñindi aka même fo wala ñindi ko hanni bel ko nata aka fo ko mbulol be sitrine ka mbulol be sitrine u katum digiri ñi sembo tala di ñi council ñaton kolla wala ya sabu kiti la ñi aka fo ko mbulol be teddere ne nte bel dino la ñi mari la même be mu do kono.
Just to put things in context,
I
was very concerned when I came at the extensive detention not only of ministers, but of so many people.
Birinna tanga de unku basoto wakata muneti hana manke minister ludam manna mutoti utumo ya tara mo jama fana mutameni yalon ko be mutoko no wotembo wakata de ngotinte.
As I said, when I engaged the chairman in that meeting
about
the release of the ministers, he refused except for the Attorney General. I did not raise at that meeting the release of any other persons. And when he released the Attorney General and I went with the escort, Alkali James Gay was also in the same room as the Attorney General.
During Attorney General labula ko fire hanufo in atante dandam pour kansamba. Ndata tu moment Alkali James Gay fanambe obunkil ngono aning Attorney General.
Sorry to
I'm just trying to put things in context.
Yes, I was wondering if you were going to come to my question.
I will.
All right, thank you very much.
I just am giving you the context.
Thank you.
It concerned me that Alkali James Gay could not be released.
Akitanya de unkoti, wairi Alkali James Gay ni Attorney General be bunkono kilingolo kono. Imanso wo bulala. Ole ndeu.
The following week, I was called to a council meeting.
Alo kungo membulata onoma yankumande purngata mabe council bengoto.
And I advised that based on, I advised that they could not keep detaining people without charge, particularly in Mile 2, because the detention of all these military officers came to my attention, and it was raised at that meeting.
Andu bring tata wo bengoto. Ngani na faje ko yimmo mutoni mo sorongo dinkira kilino tata tenten no la satara ime tu mi be mankule kan luwa nyati lingula. Kado tembo ne ajibe mo jamal le muta men yalon ko ye samba Mile 2 be mutolu kono. And
that under our constitution, there is a procedure for the review of the detention of persons under states of emergency. And they made it clear, especially the vice chairman.
Ya Senayandi Bake Sako Chairman Nolanko.
And Mr. Lieutenant Singate, who I met for the first time at that meeting.
Mr. Lieutenant Singate, may I call him senior floating nabe nyojela ubendulato.
That the detention of officers, military and police officers, would not be compromised.
Ko nyaton kolu menu mutawo nya katabula police nyaton kol la wala muto falinte keno la woto.
They agreed that they could subject the detention to reviews.
Bari sontako wo mutolu kamolu sindi isi sonne jubero ke ila kuoto
by a tribunal.
Andu membe wo jubero ke la wala ke la kitindir bundati.
They also agreed that going forward they would disclose the detention of people by actually issuing detention orders.
Andu ya nyimfana mfana kokolu bitaka nyamin ibe molla muto itandila nyamin wala nyinti ibe kangolle itandila menketa sartolti pour kaw molu muta.
In other words, as far as I was concerned,
nyado nyama ntela karola ntela mira roto.
Detention decree number 3.
Decree number 3,
which is the state security detention of armed and police personnel decree.
Me ya lonkolem decree ti meye bankola kantonin tankada bunda nyaton kolumuta ke sindidula killing.
Actually forced the military.
Amunta we sojaro lo aye iblo aye forcele.
And curb the excesses of what they were doing.
And I wole mu kuti me ya lonko etelbella na tambi kolu menu kekan pour kalo dula ke wala.
Force them to let people know
aye force fanam puri mol yalo telbe juma nyolle muta e juma nyolle muta ke sindi.
It afforded the people detained an opportunity to make representation.
Tungole nata molu mako men be mutoko no pour fanale simo nyini men be lo leye.
And it put in place a procedure whereby their detention can be reviewed.
And anata kulondi me yalon kole nyinti ko ila muto isi kan jubero keno ila muto dalilo lale.
But let me emphasize that the decree did not authorize them to arrest anyone. These people were already detained. A decree does not add, so to speak, does not empower, does not give the military any power that they already did not have.
Mrs. Bensouda, let me just interject at this point.
Mrs. Bensouda mbarunga bantambili nyaro yintimben.
I understand that your position is that when you came as acting Attorney General, you came to basically stabilize the situation.
Attorney General inata dinkiram palaso ni yata menka mawole nyindiko ka dinkira nyinta ka tembendi.
You're also saying that the decrees were just a reflection of the status quo.
And we be info ko ni decree ni mu kulle men yalon ko hakili bulandi kulle ndo yalon ko kulla nyaabe nyaamen.
And that in fact it did not give them any powers that they did not already have because they were detaining people.
And man sembo di la me alon ko mamben soto kadum ndaro yo kelon hanin kabi koman.
However, I wish to put it to you
hanin kabi nyaayo nyonya kilmo nyaambe yitandile la ko
that the decrees
ko ni decree nying
legitimized everything that the military government was doing at that time.
So Mansa be koku ke kanu ayabe sabatindile.
By giving it the force of law.
Be menke kanu anarna somebody luala karola.
First of all, let me just clarify something. The military did not appoint me as Attorney General. There is a Law Officers Act. There is a law.
Mrs. Bensouda, I'm sorry to interject again, but kindly just perhaps answer my questions first and then explain.
Mrs. Bensouda bunya kono na nyininkaro nying ajabi nga nyininka nyamendro.
You really seem to be deviating a little bit from my questions. I would like you to address them directly and then perhaps give us an explanation or some context.
It's not my intention to deviate. This is about what, 25 years ago? And the answers require context, but I'll do my best to answer your question first.
Thank you very much. And also just within the context of, the limited time that we have available as well.
And we have
quite a few topics to cover.
Thank you, but sometimes the context of your question requires clarification. What I was going to say was that by the Law Officers Act, in the absence of the Attorney General, Solicitor General takes over the office of Attorney General. Attorney General, Solicitor General, office of Tamandi. So notwithstanding whatever announcement they made about permanent secretaries, in the absence of Attorney General, effectively I was Attorney General.
Where Attorney General TJ Solicitor General Ninkum Walakalo Palaso to Kaukul Tamandi.
And not by virtue of any authority conferred on me by the military. And going back to your question, military governments do not need legitimization.
Sojarman Sakunda Lulbukanyan Kanin Kafum Komembentela Tilindila Kake Tonya Koti, Walla Kake Ku Saharimoti, Meni Sartolusita.
Their authority flows.
It a lessembo in Kamo Wakatamale.
From their guns.
And wo akabumune bala ila kilo lumenu bebulu.
They have taken over the country.
Ye banko tale.
They are de facto in charge of the country.
Amunta otembo etelebe mararim bankola.
Against our will.
Akule memandi antoliye.
The only way anything can be legitimized if it is legitimized in accordance with the Constitution.
Kokundi sitilindi no nang ayatara misali kama an inconstitutional la kama tata no nyola mosio le kumandi no tilindi rote.
So decrees do not legitimize
the action
of of the military government.
They
may give it, decrees may give it a structure.
They
may put in place a system.
They may
put in place a framework. But they cannot legitimize.
Mrs. Bensouda, the decrees give force of law. And that is exactly what it did, because even as the Constitution stands, the decrees are recognized as one of the laws in this country. And at that point, in fact, they even took supremacy over the very Constitution. If you look at decree number 1, which you drafted, although it did not suspend the entire Constitution, there was a provision that said whenever any provision of the Constitution was in conflict with the particular decree, the decree would take precedence. It would be supreme. So therefore, in my view, decree number 1 as well as the other decrees that were passed during your tenure really set the scene for dictatorship in this country. I understand.
Decree following an decree dol me along wole bulata decree following no kan wol bem keda decree le me along wole na tuturo ke kula me along sembela maralo nying banko kanjang.
I understand that you do not recognize or did not recognize the legitimacy of that dictatorship or the government at the time. However,
nganyim faham le ko iman suden roke ando iman suden roke nyintiko nyin decree nyin ko kulle me alon ko itilintale andu bar hanu kabi wonyaawo nyarandi nyama.
That was the status quo.
Wala mko nyin la nyati wo watola.
And unfortunately, in your position,
andung mantiling onyakil nyawa bari itela palaso.
And as also parliamentary, ex-parliamentary council with expertise in legislative drafting and all of that, you were very instrumental.
And we get a more melancholy Londo to Safiro to Luara Carol and then get a parliamentary council di imu molding alcohol Londo to Baka Kuinintole.
In giving them that framework within which to maneuver and navigate.
And Gedo is Jenkenole for his canono.
Thank you. I think, with respect, Council, we are confusing certain concepts, I think.
Inumbara Council, baringa mera mbekodolu jeka nyaming abekekan nyami nyololeti.
It wasn't the coup d'etat of 22nd July. 1994 was probably one of the last coup d'etats in the sub-region.
July karotil muannim flo coup d'etat ngamera asekeno wolem coup d'etat labamo timenkata nyin tundola.
From the 60s up to 1994, there were various coups across the region.
Kabo 1960 sangolula for kana 1994 coup d'etat jamal lekata tundo nyina.
Military governments rule by decree.
So jarman sakunda lukatamani decree la.
All the Ministry of Justice could do was to draft the decree for them.
Minister Bunda me marta kito nintilimala ul kamen keno drong wolem kaw decree ul safe yeni yakani.
They do not need decrees to justify their existence.
Itelu buka sula nyin decree ul la purka ila law anila sembo purka a law ndika tilindika sembentu ya.
They don't need decrees. In other words, they don't need a decree to rule.
Ni ajube nyalo nyama e man sula decree la purka mararoke.
They had removed the legitimate government. There was no decree for them to come in and remove the legitimate government.
Italia mansa kundale bondi me ya lonko wole molla mansa kunda loringoti. Iman sula nun decree la janibe o mansa kunda bondila.
There was no decree when they arrested and put the ministers in jail.
Decree ta kerin nun bribe minister lumutala ke soron kasola.
They did not need a decree to subvert the constitution.
Iman sula decree la nun purka bankola constitution on yelemandi.
But the country which they were ruling required decrees in order to understand what the military government was about. So did the decree set a scene, as you put it?
Toto decree ol kwete ya kenyaming ye kolu ye londi nyaming.
No, the scene was already set.
Hani ibotumo kolu londi nya wotumo etelio parendile.
Was I very instrumental?
Fodu ntefananga ku bambandi ntamandi jela bang.
If you mean, did we, by instrumental, did we...
You assisted the government. You assisted the military rule. Because you said they had a blueprint. Yes. So you assisted them to accomplish that blueprint simply by drafting those laws.
No, they did not need my assistance to follow their blueprint. If you mean, did I put that blueprint into a coherent framework in some of its respects?
Yes.
I was the Solicitor General in charge of the Ministry of Justice. Were we to close our doors and ask everybody to go home? No. The country needed a government. Now that the legitimate government was gone.
Mrs. Bensouda, you said the country needed it needed a government.
Yes.
You have said the government was not legitimate. You have reiterated that because you said there can never be a legitimate coup.
No, I said the coup was not legitimate. The military regime were not legitimate. The military government was not legitimate.
Yes,
but there was an establishment. Let's make a distinction between those who were in charge and the establishment that they found. I was part of that establishment.
And I am talking. And I'm talking about the military government as it stood. Did you recognize its legitimacy or not? And to be specific, Yaya AJ Jame, with his junta members, as sitting as the council, did you recognize their legitimacy at that point?
No. Nothing I did could legitimize.
If you did not recognize their legitimacy, why were you answering to them? Why were you working for them? Why were you obeying their instructions? Why did you go ahead and draft all of those decrees?
I was as I said, I was the acting Attorney General by virtue of the Law Officers Act. They did not need my recognition. They just needed my skills to reflect what they did and what they wanted to do in a framework, as I said. It cannot be called law. Because, but that's why they are called decrees. They were going to rule by decree. But the public needed to know the rules of the game. So my role, if I may just put it succinctly, my role was to prepare the instrument as requested, and that was the decree. They don't need my legitimization or my recognition. They did not.
With all due respect, Mrs. Bensouda, you're still not answering my questions directly.
Mrs. Bensouda, hankabi bunya konorong hankabi nanyin karonyi imandra jabi kang ko afurate manyamen.
And I will ask some further questions, and yes, I hope that you will assist us with answers, direct answers.
And hani ka bembe nyini karo dol nyini kala la pour isa je isinde ma pour isi jabi.
Very well, Counsel.
At that point, you had the skills, like you said, you had the know-how, you had expertise in drafting decrees.
O wato la ko ya fa nyame ya londo nyin sura ya fero nyin fanan sura pour ka decree nyin sa iye.
These soldiers with a difference had their blueprint, they had a concept in mind.
In sojarol men ya nata if inata ko itol nata nim kula nyalla mi alon ko itol bi mu sojarol mi alon ko kolbe fatala lay nin hila fansung hamol len nata ko ya fa nyame.
Which they communicated to you as the acting Attorney General.
Andu ilaw hamen ko wolu nyinga nila ferol nyi membe to yo be foyende ne tumala men ta mun Attorney General ya be karfari telamanu.
They had no idea how to carry out this blueprint.
Itol mum molde mi alon ko ma londi soto ko pour que lay hamol nyinke tamande ko luwaya yitande nyame.
They had no idea how to draft decrees. In fact, if you look at your statement, you'll see that you had to do some sort of comparative analysis between the different military regimes at the time. And using that, you had to come up with a draft which you felt reflected our unique circumstances here in the Gambia. And this draft was presented to the council. And I dare say that the contents of the decrees were very much influenced by you. Because you selected those particular provisions which you felt were appropriate. And these were later passed. Yes, Mrs. Bensouda.
I lost the question. That's a very long statement. And
it's very similar to one of your answers, Mrs. Bensouda, because your answers are also very wide, very long-winded.
What is the question, really?
You provided assistance to the junta at that time. Without your skill and ability, they never would have been able to come up with those decrees by which they ruled this country.
Personally, I don't agree. I happen to be the person there. I couldn't say that without my skills, they would not have been able to rule this country. By
decree, Mrs. Bensouda, I'm talking about the decree specifically.
The decree, I don't agree, just to answer your question first. The military, as I said, don't need a decree. They were already in charge.
Mrs. Bensouda, I believe
let me just say, it's a situation that needed a decree, not the military. Let me just say further, they could have continued as they were, giving orders without a decree.
Mrs. Bensouda, I believe your point is well taken, yes, really, on that. But I wanted you to answer whether or not, you said without your assistance, they could have actually come up with these decrees. Is that what you're saying?
I'm sure they eventually would have.
Without the assistance of the legislative.
Let me just say, the impression that people have that these are a bunch of stupid, innocent people who did not know what was going on. It's not correct.
They certainly did not have.
They had done their homework, as I said, and they knew about decrees, that military people rule by decree.
Italiela kuolu korosi ifango yenne andu itella londo to nyillo ko sojar man sekundal kamara roken decree.
Mrs. Bensouda, did they come up with a draft which they presented to you, for example? They had so much knowledge on decrees.
No, they did not come up with a draft. They asked us to provide a draft.
And you did?
Itel nin draft manade. Itel ya kanin tolle bulupur ka okaito da.
And you okay?
Yes, we did. But even if I wasn't there, whether they would eventually have gotten somebody else to draft something, I believe so. But we were the ones there. They asked us to draft it, and we did.
Nintel tijenun lata la ko itel be fere do tamandilale ibe silolu ninyin dikrolu soto na nyamin tel bijen tije andum nakata nu wonya fana abe tamala le itel be la kol kelale.
The fact of the matter is that this is not a hypothetical situation. You were the one on the ground. You were there. You were acting Attorney General at the time. And therefore, you would have been the only one to do the job at that time. And you did it.
Yes.
And that is what I want you to take responsibility for.
What is there to take responsibility for?
That you assisted them to draft the decrees.
It was my role as the acting Attorney General to receive their instructions. To in turn instruct the Parliamentary Council.
And
I did.
Very well, we'll take that answer and I'll leave it to the Commission to decide.
But whether I take responsibility for the decrees?
That was not my question. No, that was not my question. My question was that you were assisting them. That is all I said. I did not say that you came up with a concept or the idea. That has already been well established, but that you assisted them to draft it. You could have said no.
I could have said no. Probably, but as far as I was concerned, what waited on me was the public interest, what was in the interest of the public at that time. Could we contain the excesses of the military? Certainly decrees were needed. Not for the benefit of the military, but for the benefit of the people.
And are you saying, Mrs. Bensouda, that these military decrees actually benefited the public and that they were in the interest of the public? Especially considering all the evidence that we have received that this was a tool by Yaya Jammeh to entrench himself in power in this country.
The decrees that I drafted, the decree that I drafted was in the interests of the public. Now the public chose in 1997. Chose in 1997. Instead of repealing these decrees, they were incorporated in the 1997 Constitution.
In atao dikiri oluta ye dundi 1997 Constitution okono sarta buku ba nyin kono.
The greatest part of the violation of rights which occurred in this country occurred after the 1997 Constitution came into effect.
1997 constitutional in Lota, and for Atamando Damutata.
Those decrees are still in our statute books.
That
is the choice of the Gambian people, not the Solicitor General or Mrs. Bensouda.
Amanka Gambia dingulu la 40 de walla Solicitor General walla Mrs. Bensouda.
Amanka Mrs. Bensouda la 40. Gambia dingulu la 40.
Amanka ha you abant.
Thank you very much, Mrs. Bensouda. I appreciate your opinion on that. But let's just have a look, perhaps, at decree number 1. And perhaps you could comment on it briefly for us. And I will just guide you whilst you do that. You agree that the decree had retrospective effect? In its operation?
The decree was given effect as, I think it was effective from 22nd July.
And when was it passed?
Yeah, that was the day on which they took over power.
When was it passed, the decree?
The decree was promulgated on the 29th of July.
So it had retrospective effect.
It had retroactive effect.
Very well. What was the date you reported to the chairman after you came back?
The same date, the 29th.
And therefore this decree was passed on that same day.
It was announced that evening, but the publication was actually done the following week.
So therefore it was actually, was it gazetted?
Yes, it was gazetted, but as you know, I mean, you
that was done the following week.
It was done the following week, yes. I don't have the gazette publication, so I cannot tell you the gazette number and date, but it was gazetted the following week.
Yeah, gazette or local member no gazette
and of course, it's apparent that these decrees were churned out very quickly, because in the space of 15 days, whilst you were acting Attorney General, 6 decrees had been promulgated.
Decree
Yes, 6 decrees were promulgated whilst I was acting. Was overseeing as Attorney General, yes.
Wato member Attorney General ya makamo tamandikang wo decree worolo findita utumole.
These decrees, unlike normal laws, would go through different processes and would take months, sometimes to actually pass.
In decree ani luwa kota ngodol ning janni bezala ke sabat ne ke luwalti wati jamal beje kata ka dingira jamal ma folo wonde ka kari jamal da folo janni be sabat ne ke luwalti fo.
In the instance of decree number 1 was passed within 1 day after you consulting with the chairman.
Misal fe degree number follow nyim fa o keda degree me alon ko lum follow menna enin kiamanda dale o be men so lum kilo nyina ya tambindi ka ke luwati.
Yes, that is the nature of military rule. You don't have to take it to anybody. They are the executive and they are the lawmakers at the same time.
Wala msojaro la mararo Kenyati kadu kundonka ya betele bulu sembo betele bulu bitunitel preta kumen na ikatama ni wala nyam.
Isn't it true that even in this particular decree number 1, they were also the judiciary?
Fonyi mangetonya de hani decree follow nyim fanam kiti bundal fanam bejele memul judiciary.
No. If you look at
the chapter on the judiciary was not suspended.
Ani sarto membe dendi judiciary la wala mkitindir bundati maodende.
Mrs. Bensouda, if you look at the provision of the decrees taking precedence over the Constitution,
ni degree folo ni jube pour katambi constitution ni même sarre loi marale buku bañindi,
which was within the sole jurisdiction of the Supreme Court at the time, or the courts. The fact that even the courts could not question the validity of the decrees.
In
my view, gives them judicial power. Because the courts were no longer relevant. So they assumed that role.
I don't agree. Decree number 1 as drafted did not oust the jurisdiction of the courts.
Decree number 1
did not suspend the courts.
Not expressly, but by implication it did.
I don't also agree with that.
Can you tell us why? If you're not able to resort to the court, if the court is not allowed to question the validity of the decree and cannot interfere in the operation of the decree, and the decree is supreme to the Constitution, then I don't see what the role of the court there is. I am guided by my learned senior.
Kitibunda ma sembo soto ka kuta mandije adu imang ko kundin loje woto silang woto kitibunda lunafa lodulale.
I think you're referring to section 5 of decree number 1.
Namira decree number 1 wala decree
yes,
fulo la bunda lulu njango ibole mateng.
As well as the other provision that it goes to, if you read it in context, it talks about the supremacy of the decree over everything else, the Constitution and the courts.
Aduniaji be bita afita dulato dame ya lonko wolem decree nyina kebayati katambi kudo lula men ya lonko wolle be laren kata hanfo Supreme Court fon la sartol.
What that means is that the courts do not have the jurisdiction to question whatever is done by decree.
Wala mnyindi kiti bundalu itelu imang nyin lod lasu kanyinin karo ke decree nyin ay kolu menu landi wala ay kolu menu tamandi.
But that does not affect the continued existence of the courts.
Bari wo man kokundi soto kiti bundal la loning ila tamo Kenya la nibe kering.
And let me remind you that this provision
bari ngi hakilo blandi ko nyin sarto
in a different formulation
ning abelanya do nyama
exists in the 1997 Constitution.
Abakeri nun ko 1997 Constitution okono.
And it's still binding on the courts.
Andu hanimbe ataketa kuti membe larin na kiti bundalu kang.
So the courts continue to exist.
But kiti bundalu continue to katara caring.
And I did not say the courts did not exist. My point was that as far as this decree is concerned, the jurisdictions of the court was ousted.
Mafoko wato ya Trrc kiti bundal mantara tamakan. Bari ibe tamakan no wato bari komi ila lodlali nyenta kamintano umufenete miana ko mantara nje.
Insofar as they cannot question the validity of a decree, yes.
Ning ayatara decree nyin na barako ete nyinin karte kenola wala baydata kenola.
I will move on. I will move on, Mrs. Bensouda, unless you have something else to say. I'll move on to the next point.
And
it also, this particular decree actually suspended a part of the Constitution, which was Schedule 1 of the 1970 Constitution.
Wala nyin decree nyinga kete fenne de miyalonko na banko luwa buko nyinga akatam banko katama luwa buko min far sarro dolbi je miyalonko nyin decree o landele mantara tama kan koteng.
Sorry, Schedule 1?
I believe so.
Schedule 1 wala bunda followed.
No, the provisions that are suspended are in Schedule 1 of Decree number 1.
Amunta bunda lumeni alonko yedeng wolube sarto nyin na bunda follow nyin nela.
Yes, so it's suspended.
Chapter 4 of the
Chapter
Constitution.
4, yes. Chapter 4 relates to the President and his cabinet.
Sapanani njang betilindi president na la cabinet la wala ala maral kafunyolu.
And therefore the council was now sitting in that place. The chairman and the council were sitting in the place of the president and the cabinet.
Chairman ana denyol walen consulti be siri no dinkrala do mi yalan ko president na la cabinet la nyanta taran.
Yes, they became the executive.
Ay telna take kundon koluti.
And I'm aware that although there was not a wholesale suspension of the constitution, but this definitely paved the way for that happening later in Decree 30, I believe.
Na yele ko koma man ko na banguluwa buko ni ya bele londi. Imana belon bar kabru watom na yenyin decree londi ka fo mi decree 30 wole silo di fo katano.
Sorry, I don't understand the question. Pave the way for
suspension of the entire constitution.
Me silo walang pour que constitution obede.
In decree number 1, a part of the constitution had been suspended.
Decree number 1 na banko luwa buko katama minna.
And later on in
dolbi jel mi yalan ko wollo tale buka tama ko den.
And later on in Decree 30, the entire constitution was suspended, including the fundamental rights sections.
And fanani nata jibe Decree 30 wala satro bunda nying tansabo nying ni ajibe wala nata keko komin sam banko nyanta tamala luwa bugo minna yobe londele fa da fon bulata je fon hanama dingol la nyanto fon yo fon bondi jele.
I understand that you were not in your position at that point when Decree 30 was passed.
Nga fahamle ko wato mi yalon ko nyin Decree 30 iba londi kanno wayata rete man taranje.
But I'm saying that Decree number 1, which you were involved with, set the pace.
But mbafula ko yaje wo Decree number 1 mi yalon ka yetaraje wala funga silo walang fo nyin Decree 30 lotano.
No, I don't agree. Decree number 1 did not, as you put it, set the pace. Nor did it pave the way. What decree number 1 did is to suspend all those provisions which were in the Constitution, which were no longer relevant to the situation.
Walem sarto lumeni alonko itella jero to mankumma ya kolu lanya fe ya wolle den.
There was no president or cabinet.
President keri nutumo sako cabinet.
So the chapter on president and cabinet were suspended.
Bitu tumo wo bunda me marta wala president in cabinet utumo yolu den.
Most of the provisions which follow
are
consequential on those two main factors.
There
was no parliament. The chapter on parliament was suspended. So that is what decree number 1 did.
Decree number 1 la
Now decree 30, which came into force on the 29th March.
Decree sabanjango menata March karokono
1995.
Menketa 1995 sangokono.
Actually suspended the fundamental human rights provisions of the Constitution.
By
then there was a team that was advising, a legal team advising the Forces Provisional Ruling Council directly.
Otumo lua kafu sotontale menube ni sojar kafo ya marikang menube loringo palaso otumo.
These were not Gambians.
Ulumanke Gambian koluti.
And I believe their advice was that there was no place for a human rights chapter in a military government.
Nga mere itilaya maro ketanyineti ko. Hadamaya nyanta lodula manyan sotola sojar bundala mararoko.
I believe that even before decree number 30 was promulgated, in decree number 1 there was no place for human rights anyway.
Latala ko jamning decree 30 bina decree number 1 where itandiro kelako hanama dungol la nyanto woman dinkra soto wo wato nyimbango ka.
By the fact that not only was the jurisdiction of the courts which were established to protect fundamental human rights ousted,
and wobe kam fanga tara kiti bundabe loring miya lonko wala nyanta ka tankandiro ka hanama dungol la nyantola,
but also because the decree
was
supreme as well to the Constitution. And definitely we know the spirits in which the APRC junta came,
and the
various human rights violations that were committed, as you alluded to. So the spirit of decree number 1 was against protection of fundamental human rights.
I
don't agree. Decree number 1 did not suspend fundamental human rights.
Decree following number 1 among hadamaya nyanta tonyalu among hadamaya nyanta bundalu amedende.
So it enabled us at the Ministry of Justice consistently push for the military junta respect human rights.
Thank you very much. Perhaps we can move on, and I will allow the Commission to decide on that point.
Baraka,
we've looked at decree number 1. Can you just guide us through the rest of the decrees that you assisted the junta to pass?
Decree number 1 ngola kuofole. Sa mbele filame na wala nyindiko yemma koi decree mi yalanko yete double to wala kono mi yalanko wo junta mansa kundanyi wala de dano.
And to buttress my answer in respect of the non-suspension of decree, the Fundamental Human Rights chapter of the 1970 Constitution.
Anin kanna kuma kango bambandi ka foko decree number 1 amang hadamaya nyanto la kunya lu den ka ben 1970 Constitution kono nyaming.
The Monday following my return, that is the 29th was on a Friday. On the Monday,
karotil muanin kononto benta jumole febril nata bitum tenengo membulata onoma.
A state council rushed to my office.
Kitindirla soronta menyak moto futata na office.
State council
soronta menya moto futata na office.
Lawyer Mansalam lawyer mo mialonko.
And said that managing directors had been arrested.
Akoya managing director mutale.
And were sort of being paraded on a truck.
Koye bulandi moto bale kono ibe yitandikan kata
in Banjul.
Banjul sate kono.
So I rushed to State House.
Nyamoto tata State House.
Because when I met the chairman,
even
though he was talking about setting up commissions of inquiry, this is one of the things he said in his discussion with me. He had specifically said there would not be a witch hunt.
Ite bula nomo kila kabula molu noma wanyake ide mako ikabualu de manyami.
I was ushered in to see him.
And
I protested the arrest of the managing directors.
Bitungana balanda itandi ala jele managing director la mutokang.
I told him that this was contrary to his assurances that there would not be a witch hunt.
Nganyim faya woto nyinila kumakangulu fatata le kafoko ite bula no kango kela molula.
And particularly their humiliation by being put on a truck just based on mere allegations of corruption.
So ka fa ka keta ke bulandi moto kono ibe ya indila wonya kenebato ka foko ye tuminyine la ko ye nakarole.
So he called in Lieutenant Sanasabali.
Utumola Lieutenant Sanasabali kumandi.
And Sanasabali said that these people were corrupt and were criminals. That they had been taken to Mile 2. I stood my ground and reiterated and remonstrated with them. That they could not put people in Mile 2 without trial. Finally, they agreed that the managing directors would be released. And he promised to call me and confirm when they were released. And that evening, he phoned to say that he had given instructions for them to be released. I I could not have done that if there was no fundamental rights provision in the Constitution, or if fundamental rights had been suspended.
Adunte okeno la nun ning ayatara ko ye harma ya nyantolu be den walla ye dabondi kolu kono I mantara kerin kota ke tombi wol kolu te kenola.
As far as I was concerned,
ntele kundi ngola karola,
and more importantly, as far as decree number 1 was concerned,
adun ka kola kuma ya jube decree number 1 fang fanana karola,
fundamental human rights chapter in the Constitution was operative.
Hadamaya nyanto sabatindolu neng abarumalu banko kan utumode ibe lorinne.
And we, that was why consistently we emphasized that human rights had to be respected.
Walang kontinete kanyim bambandi ko hadamaya nyantolu nyante bunyala leke londi ke bambandi.
If I can just make a comment there, Mrs. Bensouda.
Mrs. Bensouda.
The operation of human rights and fundamental rights was not protected. It wasn't protected through the provisions in the decree or the Constitution. This was a special effort you made to free these individuals. And that is why they were freed. That is not how fundamental human rights operate. They should operate freely by law or by the Constitution. And as far as I'm concerned, the decree number 1 superseded all of those provisions of the Constitution. And just to preempt you before we get to decree number 3, if you remember the case of Chongan and others, they were acquitted and discharged by a magistrate. They were basically listed in the list that was attached to decree number 3.
And they were security detainees. And komi molle milia tanko bunda mol dokula molle moita and ye mutale ye mabo.
Despite the fact that they were acquitted and discharged,
yimbe kanko komin kitio nata fola ko nge bulale kitio ye bulale andite murundi nola ye kitindi ko bang nyanta tinyal minke wala ye kuol minke.
The overriding power of decree number 3 applied in that instance.
So therefore,
like we said, even though the courts were functioning, as well as the rights under the 1970 Constitution, however, the decree superseded them.
But decree le nata sembo soto katambi wo lua bukubati.
Was that a very long question again?
It was a statement.
I'm going to ask that you agree or disagree with the statement then in that case. I'm putting it to you. Let me shorten my question so that I can get a direct answer from you. Do you remember the case of Chongan and others?
Not the details.
What
is the date of the case?
I do not have the date of the case, but this was sometime, I believe, in 1995, if I'm not mistaken. I'm sure you're aware of Chongan and others being arrested as security detainees immediately following the military coup. Were you aware of instances where security detainees were discharged or acquitted by court, but that could not happen because of decree number 3, which you drafted?
Foi hakilo bakane ko mol mi yalan ko ko tanko bunda mol le muti ye samba kiti ndiro la kiti ona te bula but wo bula ro ni amanna sembo soto no kadu decree le bije mi yalan ko man sakun a wo man sakun dambe kering ye fan sujini wo decree la and wo decree etele moti mi yalan ko ite fongle ya safe.
Which provision are we really talking about in decree number 3?
Mbe sarraj mal fo ka nyin decree number 3.
We're just looking at the generality of decree number 3.
Decree number 3.
If you look at it, it states that the supreme power resided in the council to detain members of the security forces. And that because the decree overrided the Constitution as well as the courts, just like in decree number 1, the hands of the courts were tied. If you look at 2.1, I'm looking at decree number 3.
2.1 of which of the decrees?
Decree number 3.
Decree number 3.
Yeah, that is state security detention of armed and police personnel. Yes, it says that where the vice chairman of the Armed Forces Provisional Ruling Council is satisfied that the arrest and detention of a member of the force is in the interest of the security of the Gambia, he may make a detention order in the form prescribed. And that is the general order to make detentions, to order for detentions.
Akamumva wala nyindiko mimbe safari woto wala nyindiko tanko bunda mol chairman sa fono le ko wala la wojunta chairman wala nyaton ko nyinga sa fono le ko nyimo tanko bunda mo nse mutano le na tara ko chairman ya jelo ko wala wo mutaro nyinga jarta la priye muta asina kangodi ko ye muta.
It also states in subsection 2 that in fact the vice chairman may direct the place that the person is going to be detained.
And fana sarta do fana tato bala mi ala be chokeni wo bala mi itandro ke ko mi alon ko wole sinno be chairman no wose ya maro dino le ko mi nyimol mi alon ko ye muta wolen tanko bunda molti isa fono le dinkral to mi alon ko nyanta ke mabo wolle to.
It goes on further in subsection 3 to state that the conditions of detention are also determined by the vice chairman, including even as to confinement, maintenance, discipline, and punishment for breaches of discipline.
A continue to fan kafo fan ko min dinkral to mi alon ko nyanta ke mabo damento wo be sembo tata chairman no malan ko lebul fo min tate la kulo la karole la taranyala karole nyanta min lale kan.
And we all know that even in the case of Chongan
and be alone ne min keta Chongan la karola
and Mama Cham and others,
and Mama Cham na munyol
during the period of their detention,
watu mi alon ko be muto kono no
on the 6th day of September 1994,
wala kada September karoti woro 1994,
members of the junta,
mol mi alon ko wolle dabe nyin junta kafo kono
except the chairman himself, went into mile 2,
fo chairmano damale mantara nje tata dum mile 2,
subjected them to brutal torture,
ke muta ke tajiriya
as well as a mock execution.
ndum fana ke mol muta ke fawo dinkra fonto.
And who knows if that may not be a lawful interpretation of maintaining discipline and punishment and all of that.
Anjumala ba fola no ko mu nyale te mi alon ko isa fono la ko komi be tilingo anin ka foko ka kuluo la mol ka nyinem silo te mi alon ko wala nyanta kata.
But I assume that would be under the exclusive purview of the vice chairperson the vice chairman to interpret.
Bare ngalo ne ko wobe tuta chairman o nyine bulu wala vice chairman o nyin ko ma bo ko tala nyandu le ka foko ka firing.
But Mrs. Bensouda, this is the decree that you drafted, and you gave extensive powers
Mrs. Bensouda
to members of the council.
Nyin decree luani fenne mi yalon ko ite fongole ya deda andu ite fongole nata murun ko de yesembo di nyimolla.
The decree sorry, you expect me to respond, I suppose.
Of course I do.
The military officers, Chongan and others, were already in detention when this decree was was promulgated on the 4th of August 1994.
Sojarolu dik chongan ya monyol utuma ulbe muto konole wato me benyin decree bondila August karotil na.
Let me just interject there, Mrs. Bensouda.
Yes.
Sorry, I don't want to lose this point. We've already discussed that the decrees had retrospective effect.
Nga kaja jana ko komi nyin decree mi yalan ko ye londi na dana ko ya ku
and I'm putting it to you that the reason why they had retrospective effect or retroactive effect is because the council wanted to give some sort of legitimacy or force of law to their actions in case somebody decided to challenge it.
Yo get dalilol min kama wala nyindiko isaje tol council mol fon isaje ko ye kuo kuke ye tilimbalia ko wala ye kuo kuke andong ya ko milla natara wo maril pareta pour que samba kiti dulat e be min kala dore be fan suje la ni la nyin decree luwalla
because even though the decree was not passed when that action took place, but then the law gave it validity.
But hani wo be kanko ayatara fon kabri bo ko wol nyin ke kan ayatara nyin decree nyin amanlo but hani say nada na sembonti ya ni luwala
because of its retroactive nature.
Katu ko mine wotina katu ya murundi ko mala ko min ko wol min be katano.
Learned Council, with respect, no law can give validity to torture.
Luata kerim meye nyin tonya yandika momuta ka tajiriya.
These military officers, as you mentioned, were already in detention.
We had
instructions to draft decree number 4. At least for the future, just taking the sections that you quoted one after the other. But what decree number 2.1 made possible, at least for those who were not in detention, that they could not be detained without a detention order. Decree number 4, or section 2, subsection 2 and 3.
Decree na ninjango alabunda fulanjango fanana bunda lulula fulanjango ni sabanjango
did not empower anyone to torture persons in detention.
To
the extent that the fundamental human rights provisions were still in force. The decree assumes that all detention would comply with the fundamental human rights provisions.
Decree was
So to say that because the decree was given retroactive effect, that probably legitimized torture that was going on. Respect is not correct.
What I was saying, that it legitimized the actions of the government. Especially when it came to it certainly legitimized unlawful detention as we know it in the Constitution. Because the procedure in which they detain people, and the evidence is quite clear here, the TRRC was definitely not in consonance with the provisions of the Constitution. And that, in my view, paved the way for other human rights violations such as torture.
Decrees
cannot legitimize the actions of the Armed Forces Provisional Ruling Council. It cannot legitimize torture. It cannot legitimize detention. What legitimized? Sorry, the translation.
Decree tenying keno la ka foko ka tilindi wala ka kesartoti pour ka mulu muta wala ka molu tajreya wala ka kujawol ke molla ke dimindi.
And the Armed Forces Provisional Ruling Council knew that the only legitimacy they can get for their action during the transition period
andu sojarolu tumo itelia lonko ko men si itelu lakolu sambano ay keko kutilindi ngolom itel lamararo kono
was to have an indemnity in the Constitution of the Republic of the Gambia.
Wolem ka bunda londi Gambia la Constitution o kono me ya lonko wolebe kantaro kala molu la men ya lonko ni o kolu ke satara kute kelela.
That is why they went to the extent of ensuring that we had the second schedule to the Constitution, indemnifying their actions during this period.
O dalilo le ya sabu itata ka bunda fulanja nyi murundi na Constitution o kono me ya lonko wolebe itali kantala ila kuketa lutobe menu kala wo sartol fanan la karola.
And let me also remind you that legitimization must have an objective yardstick.
The
A decree which is made by the military cannot legitimize what the military does. It's the decree is made by them. They cannot legitimate their own actions. So legitimization connotes that some other process is used to give validity to something a person does.
Decree olu nyili ate keno lako itel fangolu yo decree ol de rapurke itel fangol law kuketa lu tilindi. Bari we kule itandi ko kule be dendi ngala meya lonko itel seo men keno wala mnie memmenke wo decree olu sike kuti si denno menula.
So with respect, Council, legitimization in relation to decrees is a misnomer.
Woto ni ajibe Council ka kuolu tilindi ka fo aya tembendile sartol la karola. Woto mukule timeya lonka ninyan tolu man tembe.
It is the Gambian people in the Constitution, 1997 Constitution, which supposedly went to a referendum that legitimized the actions of the AFPRC.
Birin Gambia no liye kon referendum o nyinke carte o fayi. Hani fo wo sartolu menu dunta 1997 Constitution o kono. Wale olu sembentu ya ke londi pour ke kuti men sitama.
And from 1997,
between 1997, Lungulu,
those provisions in the Constitution legitimizing and granting indemnity to the AFPRC remain in our laws.
Wale asabu, lusarto lumbeni itelikanta ke tankandi tilindi Roma, wale tutala Constitution okono, wale akendi itela kuketalu, kumana boje mensi ke tolula kafo ya nyineke.
That is why Yankuba Ture was able to raise it.
And
if you look at the judgments of our courts, consistently from 1997, they have excluded themselves from having the jurisdiction to determine the legitimacy of decrees.
1997 woto ninkumu itelie fam bondile ke fanjam fandi wo sartolu lako ulmu kulleti men ya lon ko askeno ko kusi soto men se ke tolla wala bulusile kan.
So I think it is wrong
ngamira manke kutilindi nguti
to try to infuse decrees
pour ka decree
with an authority that they don't have.
Pour ka decree wol ta ka ning sembe dundi nyola sembo men ya lon ko etelma soto.
As lawyers we know this about law.
Law
is merely a command that can be enforced by sanction.
Where
the decrees law during the transition period,
to the
extent that they reflect commands which had sanctions, which had consequences if you don't abide by them, those that were directed at people.
Maybe you
can call it law. But to the extent that the Gambian people did not have the military did not have the consent of the Gambian people to make the decrees,
and
they were not laws. That's a philosophical debate.
I was about to say that, Mrs. Bensouda. Looking at the practical realities on the ground, as far as the Gambian public was concerned, the decree certainly had the force of law. As far as the military junta as well was concerned, they ruled by it and used it as law operated in the normal setting. And by these decrees, remember, Ms. Bensouda, you drafted them, they were equipped with legislative, executive, as well as judicial powers.
And Ms. Bensouda, you decree me in Kafoteng, and you take it a motimian ko itala deda. Yes, symbol like a million coal and kitty bunda symbol, lua deda symbol, and ning million ko mansakunda nyaton ko la symbol fana.
And these decrees actually validated their own unconstitutional actions.
And fana nyin decree keta fenati million ko ye londiri ke ko la million ko akamtalo ko dro ning banko lua boku babe tamaka.
And in your position, you helped them to achieve it.
And do ite fongo kundingo watu mene bo makamoto iketa multi million ko ye demale pour ye ko tamandino wanyama.
Well, the premise of your question, if the question is whether I helped them, that premise, of course, is wrong, and I don't agree with it.
Ilo dinkira kafo nyinin karo kono kafo kufa fodu ntele imako yukulu tamandola natara wole mude woto manso woto la mbafala ko woto dal amanke kuti ntenya ko to mentilinta.
And I respect your answer, Mrs. Bensouda, and I will allow the commissioners to draw conclusions.
Ila jabiro mba bunya la bakale andu wakang mina abulala commissioner bulu police jiberke ya woko nyintame ya jibe.
The decrees did not validate anything done by the council. They did not need validation.
Decree olumam fewo fendi bambandi ka londi ka foko nyimuku ketalti council nyin nakarola. The
decrees provided a framework for them to operate, in which they operated. It was created by them. It was enforced by them. It was amended by them when they saw fit. In fact, even where the decree said they could not do something, it did not prevent them from doing it because they had the power to do it.
Then
one might ask, Mrs. Bensouda, then what's the point? What's the point of the decrees if at the end of the day they would have done what they were going to do without it, and they were ruling anyway without the power of the decree? Then what was the point? What was the point for all of the framework and guidelines that you presented in the decree in that case? Because they were not bound to follow it anyway.
What is saying, Ms. Bensouda? Most in karo kenol. But in saying you'll more let me uncle decreeing Hanatara Lota, what a balla, it will left a cuckoo kele bakela, far tata insular, farmantan insular. In my
view, I mean, you might as well not have dirtied your hands by touching them. Just let them do what they're going to do.
Until a miralota, Imanian Dakelanunje for a bullon non did the Yenta Silla ye fele to Bemin Keka ye walkadron.
I do not consider my hands to be dirty.
I
do not certainly consider my hands to be tainted.
But
it's a fair question to ask then, what is the point? I suppose it's convenient 25 years down the line to be asking those questions. Were we all to abandon the country and leave it to Yaya Jammeh and his cohorts? Should I have resigned as Solicitor General? Should I even have stayed in America? These are all hypothetical questions 25 years down the line. At that time, having worked in the ministry for 5 years, Sorry, for 14 years. 14 years at that time, having been Solicitor General for 5 years.
And
knowing that the situation we found ourselves in was not unique to Gambia. And taking a point of reference from how other countries, Nigeria, Ghana, Liberia, Sierra Leone, how all of them have dealt with the situation.
Ko banku dolu ya akwoke nu nyami mbiri aketela bankolu kang menu beko Ghana, Nigeria na nyom banku kotengolu niyo santingolu jube.
I took the decision
ngawo kangota nyine kang
to come back
purka murunang
and Solicitor General continue to work in the public interest as is my oath.
Solicitor General purka continue do ko la jama molu toyala wairi ngakalioleke.
So, in your view, you were some sort of savior, Mrs. Bensouda. That's the picture I have in my mind when you describe the situation where if you had not actually intervened, this country would have gone down the line of chaos and anarchy. But for your intervention.
Coming ndala miralo to ngaja nyame wala nyintiko komi na tara no itamane da bula nyunko konono deno nyim banko be kala banko lete mialan ko kairo nin tenku ngote tara no nin banko kan wo wato kon.
Savior, I wish I was. No.
Ka fo kanandirla ngam asidia nyunu ngake oti hani manke oti.
I really wish that the military who had the responsibility to secure the safety of this country
I
was no savior. However, the country was in anarchy. And what is anarchy? Was in a state of lawlessness. Where soldiers can knock on your door and throw you in prison. Other countries put in a coherent framework so that the military could interface with the public. And that's all decrees are supposed to do. Create a framework so that people will know what to expect from the military. And hopefully, the military will also understand the limits of their own actions.
But
let us not fool ourselves. The soldiers were in control and could do whatever they wanted.
The
decrees did not enable do anything.
But Mrs. Bensouda, it's very clear that the situation you explain about regulating and stabilizing the situation, I mean, it definitely did not happen. Perhaps that was your aim and that was your objective, but it definitely did not happen. And you have also confirmed that because they did what they wanted. Do you have any regrets?
Ms. Bensouda, mimbi wala nyintiko ita natala nung pruka demarke isaje kuol belari no nyamin tinyarol mimbe kering abesebo wala mila xamendatu no barkabri nat inata jele ko wo kuol nying wo xamendal nying imanna wo natol timandino sambe nyini ngala mina foy ni misata nyum kuol la bang milketa.
Regret about what?
Kanimisa munna
specifically.
Tombondiroto kanimisa munna.
Regrets about drafting the decrees.
Wala nyindiko yewo nyindikri lual mi yalanko yewo le deda nying juntamole.
No, whatsoever, none.
Ani akita nyanyandi nyama fentiji.
Okay, thank you.
A framework was needed.
Even though it wasn't followed. And it was disregarded, as you said yourself.
Not everything. I did not say all the decrees were disregarded.
You said the soldiers did what they wanted to do from the beginning, even before the decrees were passed. Therefore, what was the point?
Let me repeat. The point was to create a framework within which they could operate, whether they followed it or not. That was the framework.
Sarto momenti wala mnyintiko kakuolu sambanya ning atamandinya parendi. Itatabula wonoma bang, imanta abula wonoma bang, bari ninku dedata me yalonko anyanta kela wole nyama, adedata wole kama.
So even if it served merely decorative purposes, it should just be there as a guideline, even though no one was guided by it.
I think it's a wrong opinion to say that they serve decorative purposes. Just to give an example, Decree number 1 enabled them to, although they had made a declaration about the cabinet.
Decree number 1
Decree number 1 gave them the structure within which the cabinet members could be appointed and could sit to address the myriad of issues that had nothing, that the country needed to be addressed, that had nothing to do with the military.
Decree following wole silo itandila inyanta kolu tamandila nyami inyanta kolu londila nyamin me ya lonko itella mararo kono be kolu tamandila wole nyama decree following yo bundale yele itelie pour salon be kolu sambala nyamin.
The decree also enabled the government to know that it will continue to function under the laws that were in place.
O decree fanane nyi itandila ko ibe tamano lale luwa lukoto menia lonko wolebe loring inyatili nyal.
In other words, decree number 1 enabled the public to know what the situation was and enable life to go on.
Decree following na fananata jama mako ipuru ya long munebe caring anim fanam puru molu la sinya nimbalunya sitenteng.
In other words, decree number 1 was the MOU, Memorandum of Understanding, between the people and the military, if I may put it that way.
Ninsa fono wonyama decree following wole munyo fahamu kamati jama molu ni sojarolu tema wotembo.
Just like a constitution is the memorandum of understanding between the people, the governed, and the governors.
Constitution munyo fahamu kamati nyamin jama molu iniman sakunda ning maralu bundalu tema.
So we should not infuse it with some other, some other attributes that.
Yeah, Mrs. Bensouda, just to conclude, really, certainly it is clear, even from your own testimony, that the junta never had the consent of the public to do what they were doing. So I don't see how you could call that an MOU between the people and the junta. You said their government was illegitimate, and we've gone through all of that. So I don't see how that could be an MOU.
Ms. Bensouda, comme ifon ya fanyame, nta maje comme ika faname fo comme banko lua nying buku banying woning mol tema comme iko mu feneti miala ka fa memorandum of understanding wala nyomo yole be kering da mol tema o man ke fenti miala ka keta wala nyam bunya be kamala.
But in order to
it's a good point
that
you make.
Thank you for acknowledging that.
The memorandum of understanding did not require the consent of the people. That is true.
But not that it did not require it. It did not have the consent. The people never consented to this.
I think we are saying the same thing.
I'm not too sure, Mrs. Bensouda. I doubt if we are saying the same thing. I'm saying something very different.
It did not require the people's consent because they were ruling by the barrel of a gun.
And the people never consented to that. Sorry.
I mean, one can debate all these issues, mostly philosophical, but let me make it absolutely clear. I would like to underscore it.
ndumbela flaka bambandi
I take no responsibility for the actions of the military.
sojaro labara kolunta ak femfem duno talaje.
And for those of us who try to stabilize the situation, I think we, in fact, are entitled to commendation. I feel neither tainted by what happened or the role I played. And whatever I did was entirely consistent with my duty to the country and my duty as Solicitor General or Acting Attorney General.
Anim banko la solo ni sarto lutata nyolale anim fanam palaso membembulo tumo Attorney General makamo anio fanana sarto ni tarambulo lutata nyolale.
And I understand your point about not taking responsibility for the actions of the AFPRC.
No fananga fahamo kele munati ne mansong coming ning AFPRC mansakundani wala njunta nyinti la manyal mi yalanko ya wala kenu.
And let me just
finish my point, Bensouda, so that I don't lose my thread of thought, please.
But let me just
finish, please. Please, with all due respect.
I'm at the listening end, so I'll give you priority, yes.
Thank you very much.
Yes.
I really appreciate that. Despite the fact that you're saying that the AFPRC did not actually you've succeeded in helping me to lose my trend of thought, which I'm sure that was your
I'm glad
your goal.
not really. I'm glad you understand my difficulty when you make these long statements and expect me to answer.
Okay, go ahead and answer, and then by that time
I just wanted to add, and I take no responsibility for the decrees. I take no responsibility.
Very well. You have now reminded me of my question.
Yes. I thought you were going to, in fact,
yes,
yes.
Yes. In terms of coming up with the concept and the idea, the blueprint for the decrees, I understand that. But do you not take any personal responsibility for assisting in their drafting? Coming up with an actual decree and placing it on the table of the junta?
I don't understand why I should.
They had no know-how, they had no skill to draft decrees. I doubt if they could have made an effective review of those decrees at that point. They just took whatever you said, as far as I'm concerned.
It all man londi soto komi word decree ni nyanta ka adeda nyame. Andu na taro num fa yel fellon nu jefa. Denu kabi wato minete adeda be minkela ni ba se tanjibe la ka jibe yemin deda. Bari mo fon keno.
The suspension of the constitution, suspension of the courts, and all of that.
Because kitty dunkral deng ka bankola bukulua ba fana deng.
But it was reiterated in the decrees.
But why
was there need to do so? If their actions had force of law anyway. That's what I'm trying to understand and reconcile with. And I think that the general public as well really would like to understand that. You know, as you said, sometimes there can be a philosophical debate as to what is law and what is not, but in practical terms, what was operating in this country?
But honey
what was operating in this country before the decree was nothing. Nothing was operating.
When
I came back, nothing was operating. For the 1 week, the military were doing exactly what they wanted. And people did not know. And people did not know the framework within which, what was going on, the framework within which this military were operating. I call that anarchy. So maybe I don't understand
the framework really had nothing to do with what they were doing, because they continued to do what they were doing anyway. The framework did nothing to limit them or restrict their actions. They continue to unlawfully detain people, they continue to torture people. Even after passing of the decree. So what was the framework all about?
You must remember also, I mean, I agree that they continue to do what they wanted. So decree or no decree, they would do what they wanted. Right? You must recollect that the vast majority of the decrees that were passed during this period had nothing to do with the arrest or detention. These were just regular decrees that would have been passed in the National Assembly for the good functioning of government.
But for
now, and for the purposes of the TRRC,
no,
it's
very important to put TRRC cannot be the issues of the decree in the TRRC cannot be handled in isolation. There wasn't a set of decree that had a life of its own that violated the rights of the people, and another set of decrees that were applicable in terms of the functioning of government and so on. The decrees were decrees. So yes, when it came to the decrees that affected the liberty of the subject, the sanctity of the human being, this is what the TRRC is looking at. But it should not be looked at in isolation. So I'm quite concerned that the decrees are being infused with some sort of, I don't know, attribute that don't exist. Decrees were just rules that were put in place. Now when it came to...
TRRC be jube romen ke kan wolem ka jube o dikrilu ye londi ay men sababu akola anin akata menti ibewle jube kan pour ka kursanu soto je men muto nyati dikriolu ye men sababu ani mam men sababu bar ni aji be fanan wolu kolu mukulleti men yalon ko nyilu bela kolu ke kan dikri bi soto taban dikri man soto ban itel bela kolu tamandi kan nyaado nyama hani wato me o dikriolu mallo.
Because of our mandate, sorry, Mrs. Bensouda, because of our mandate to investigate human rights violations.
I agree that there are a set of decrees. There are a set of decrees that, of course, are crucial to your mandate.
Yes. We must focus on those.
Yes, decree number 1 is not one of them.
I disagree.
Decree number 1, yes, of course. The decree number 1 merely set the basis for government by the military.
Decree folonye kolu lanya le yitandi sojarolu la inyanta ilamansa kundata man.
What about decree number 3? Do you agree that there was room for the junta to violate human rights through unlawful detention?
Decree number 3 nyundum foya mira we silo di junta la priya hadama dongo la nyanto tinyama.
No, in terms of Silodi, as he put it, it did not...
I don't understand Mandinka.
It paved the way.
It paved the way.
You are agreeing that it paved the way,
or
you're not agreeing?
No. They were already violating human rights. What the decree did was to set down a procedure which should be followed if people are to be detained. There must be a detention order. Yes, it did not take away the right of the vice chairman, his discretion, which he refused for it to be taken away. It did not take away his powers to deal with the detainees in terms of where they should be remanded and so on. But it put in the minimum that I think we should be, I and Cherno worked on these things.
Decree follow dali lomenti wala mnyenti ko kasilolu nin tarambulolu londi ning itelu sonta nung purka tama menula men ya lonko wollebe kala kukendolti isi mararo keno nyami ndani Cherno denta ngawo silol le doku
ibe
ya lonko wollebe kala tarambulolu
ibe Cherno jumale ka Cherno jumale fote.
Oh, Mr. Cherno Jallo QC. He's now a Supreme Court judge.
Supreme Court
We grew up in a democratic, as lawyers.
We grew
up in a democratic context, in a context where fundamental human rights were supreme.
So how could you put your name to these decrees, Mrs. Bensouda, taking that into consideration? I mean, with everything that you described about the democratic setting of Gambia and respect for rule of law and human rights, and then you assist in drafting, or I would say that you drafted these decrees that suspended the constitution.
Komi nata silol mi itandi komi Gambia banko kan demokrasi kata manyama hana madungol la nyanto hani wobe etenate dabula nyim decree economy alan ko yewolle de daten.
Ousted the jurisdiction of the courts and gave legislative powers to the
ka kiti bundal deng ka sembo di mol la mi alan ko lebe maralo ni wo wato kono.
That is not in consonance with democratic principles as we know.
So in
my view, I would not have touched those decrees. But your opinion is that, although you don't want to say the word savior, but you did come to save us.
I'm glad you are not me.
Indeed.
We acted responsibly.
Mrs. Bensouda, I think we'll agree to disagree at this point, and we'll close for the lunch. I'll just refer you to the chairman before we do so. We will break for the lunch, not close. We'll come back after lunch. Thank you.
Thank you, Thank you, Council, and thank you, Madam Bensouda. We will resume at 3 o'clock sharp. Thank you.
Thank you, Mr. Chairman.
Yeah.